Hey, Lasash here. I'm an attorney in the Southern District of California here in San Diego. Every Wednesday, I pick a case and we discuss it in detail, trying to figure out your constitutional rights. And then every Friday, I recap the week, try to focus on the big news, usually dealing with criminal law, but not always. Hopefully you enjoy this channel. Hit the subscribe button. If you're new, like I said, hit that subscribe button. If you're a returning viewer, thank you so much, especially lately, for sharing my channel with your friends and family. It seems like the numbers are growing. I really appreciate it. If you'd like to support my channel, consider going to losthash.com. Take a look at some of the merch, including the Do Not Arrest This Person t-shirts. So let's go on, take a look at this week.
Subscribe to the Lost Ash YouTube page. That's LAWSTACHE.
We began this week with Justice Department publishing a proposed rule to reclassify cannabis and began accepting public comment. The Department of Justice proposed a rule to reclassify cannabis from Schedule 1 to Schedule 3 of the Controlled Substances Act. What does that mean? Well, if you read the statute, or if you just go online and take a look at some of these tables that some individuals put together, you will see that the penalties for different schedules of narcotics are significantly different. So what it means is, with this reclassification, a person who's caught with distribution, possession, dispensing of marijuana would still be subject to criminal laws and regulations. What it doesn't mean is that the federal government is decriminalizing marijuana. This proposed rule does not affect that. What it also doesn't mean is that the federal government is somehow legalizing personal use or medical use of marijuana. The reclassification between Schedule 1 to Schedule 3 simply means that the penalties would be different and it'd be a little bit easier for individuals to use marijuana for purposes of research. To learn more, take a look at the link that I will publish under this video to learn more on this topic. Now, the second news this week is that the Supreme Court has published Brown versus United States. And this case deals with mandatory minimum sentences. Whenever you're in federal court, you have to always be mindful of mandatory minimum sentences. This means that the legislature has taken the power from the judiciary, from the judge, to give a sentence lower than whatever is mandatory. What does that mean? It means that as a criminal defense attorney, even if I have compelling reasons and try to argue to the judge to give a lower sentence to my client, if the mandatory minimum sentence applies, that means that the judge is unable to go under that mandatory minimum. Now, in this Supreme Court case, it dealt with Armed Career Criminal Act, which mandates a 15-year sentence for being a felon in possession of a firearm if the defendant has previously convicted of 3 violent felonies or serious drug offenses. Now, the question became, what does it mean, serious drug offenses? The parties propose 3 different answers to the question whether the federal and state definitions of drug must match when the state crime is committed or at some later point in time. Of course, whenever we deal with individuals' criminal history, that criminal history might not necessarily be federal crimes. It might also mean state crimes. So forever the rule has been that in order for us to figure out violent felonies or drug offenses, if the individual has state criminal history, state offenses, the definition is that the drug offense has to match one that federal law also prohibits. So the government argues that the prior state drug conviction qualifies if the federal and state definitions of the relevant drug matches when the defendant committed the state crime. Meaning, let's say today somebody's charged with being felon in possession in 2024, and we look at the state case, let's say from 1980s or 1990s. a long period before. Whenever we look at that statute, the state one, let's say that that state or the federal law no longer matches in today's world, in 2024. The government proposes that we have to look whether it matched when that crime, the state one, occurred. Now, one of the defendants, Jackson, argues that instead the definitions must match when the defendant violates the federal felon in possession statute, meaning that we have to look whether the match occurs when he committed this crime, being a felon in possession. And because this was a consolidated case, another defendant, Brown, contends that the definitions must match when the defendant is sentenced for the federal felon in possession offense. By a 6-3 vote, the justices held that some state drug convictions can trigger a federal sentence enhancement even if the drug involved is later reclassified under the Controlled Substances Act. So this actually kind of goes hand in hand with our first topic, where the marijuana is being reclassified. Well, here we have that no matter reclassification, the Supreme Court says that we have to look whether it matched at the time that previous conviction occurred, the state case or the federal case, during the time it was occurring back in 1980s, 90s, 2000s, or whatever it was, but not today. So they agreed with the government. This is a big win for the prosecution. And our third story is kind of a crazy one. Alabama driver ordered to say sorry or face jail for telling the officer, "Get your ass out of the way." This is the weird one. We have an individual who gets pulled over for a traffic offense. After he's issued a ticket, apparently the officer got in front of the car and would not let this individual go. So the driver opened this window and yelled out, "Get your ass out of the way." The weird part about this story is the judge now is telling this individual that he needs to write an apology letter to the officer for saying these words or face 30 days in jail. I will tell you this. Whenever I have a case and somebody either pleads guilty or we go to trial and unfortunately lose, whenever we're at sentencing, I always tell my clients that of course they have to accept responsibility and apologize to get a lower sentence. The weird part about this story is that of course this individual is not being charged for what he said. He got charged for the traffic offense. And if that's the case, all he has to apologize for is the traffic offense. And if he wants to pay a fine or do whatever, the judge can order that. But the weird part, it's weird for the judge to be ordering some apology letters for the crimes that were never charged. Well, let's take a look because this case will go on. In June, this individual will have another court hearing and we'll see what the judge orders. So I'll tell you about it when we're in June. For now, these are all the 3 stories that I wanted to share with you. Thank you again for giving this video a thumbs up, for subscribing to my channel, sharing it with your friends and family. If you're listening to the podcast version of this recording on Audible or Spotify, please give my podcast a 5-star rating. And finally, if you want to support this channel, consider going to loststash.com and check out some of my merch, including the Do Not Arrest This Person t-shirts. Thanks a lot for watching. See you next week.